as they are coinciding. And so I'll just skip to Article 25 of the Maputo Protocol, which provides that that state parties who are signatories to the Maputo Protocol should provide appropriate remedies to any woman. Of course, the protocol also covers girls, any woman whose rights or freedoms has been violated, and ensure that such remedies are determined by a competent judicial authority. And I argue that the employment of TDRMs in child sexual abuse cases is broadly at odds with the constitutional obligation to access to justice. And I also advance that these mechanisms have no place in the resolution of sexual offenses, and that they in fact deny victims justice in formal legal systems, which lead to serious breaches provided by the constitutional right to access to justice. I also talk about the low economic capacity of women, of who I term the non-offending parent, who is usually the mother in child sexual abuse cases, who has the duty, or usually has the duty or the responsibility to report child sexual offenses on behalf of the children. And I argue that there's a very complex legal systems, and the child needs their parents to navigate through these court systems, and to do so, then the child is left in a situation where they cannot access justice. And I talk about the low economic aptitude of police officer to even get justice, and generally the fact that courts are not accessible to the common mwananchi. And I believe that that is in fact the reason for the persons opting to get for informal settlements outside of courts, and not necessarily because of their attachment to their cultural heritage, but because of one or two things within our formal court setups, including the fact that our courts are currently laboring under a heavy weight of burgeoning case logs, the fact that it is nearly impossible to successfully prosecute a case where you do not have forensic evidence. And our courts place a lot of emphasis even on technicalities, and your case can be simply thrown out because of technicalities, despite the progressive civil procedure code criminal procedure code that we currently have. So I talk about, my paper is divided in 3 parts. I talk about the role that the parent has in reporting the case, and I interrogate whether or not these parents have a duty to report. And apart from that, I also look at the instances where a parent may not report the sexual violence of a child because of, say, they are afraid of their child, of their lives or the life of the child. So those are just some of the things that I look at in this paper. Lastly, my last chapter is on the role that police officers have in relation to TDRMs, and the role that they have in informal court settlements by the citizenry. And one of those reasons, by my own just general practice, I've seen that very many instances where you have a client coming to you and they tell you that I went to the police and they reported the matter, but instead of the matter being reported and being advancing to the DPP stage and so on, these police officers actually take it upon themselves to adjudicate are entirely beyond the scope of their employment. And what they will do is say, they will gather the perpetrator and the victim, and they tell them, you should say sorry, and this is something very shameful, and if it gets out there, then this is going to be a very big issue. So let's settle this, and let's not go out of court. Let's not go on to the court systems. But you also realize that the police have some benefits to, to this whole system where they're adjudicating cases outside of courts. And one of those reasons is, one of those benefits is the fact that they will allocate damages, quote unquote, because this is outside of courts. And in that process, they will allocate some of the damages directed towards them. So if the client is being paid 4,000 shillings by the perpetrator and there are 3 police officers, everyone gets 1,000, 1,000, 1,000, and the victim gets 1,000 bob for their rape. And I'll also refer you to a very infamous case. A couple of years ago, we heard of the case, largely covered by the media, the case of Liz. This girl was gang raped, 16-year-old girl, gang raped by 6 men. And instead of the police reporting this case, what they did was they asked the perpetrators to slash the grass within the police compound. This girl had been gang raped. She had been thrown into a pit latrine. Within that time, she had broken her back, and she's paralyzed to this date. She had fistula. She was in a pit latrine for 3 days before anyone found her. And instead, our police ordered the perpetrators to slash grass. Okay? So these are some of the issues that really make me agitated within my practice, that we need to really look into the role of the police officer acting as a secondary perpetrator to sexual abuse. And I refer to the case of CK through Ripples International, which was one of the first instances where the courts actually recognized that the police are in fact secondary perpetrators because they re-victimize victims. They stigmatize the victims. They make it difficult for the victim to report the case, and they encourage out-of-court settlements. And during that particular case, groundbreaking case, was extremely important because they recognize the police as the secondary perpetrators. But aside from that, I think what I kind of wish was said within that case is that vicarious liability kind of shields our police officers from personal liability. And if you look at countries such as Ghana, they actually state that we will personally come for you if you adjudicate a case outside of court. And so these are just some of the instances where we can make that system better so that we are encouraging people to seek formal court settlements. Secondly, with the issues to do with parents, I look into the issue with, the low economic aptitude of women. Instances, for instance, in Baringo County, there was a woman who stated that she can no longer pursue the case of her child because her husband has sat down under a tree with the elders, and they had decided that a payment of 1 cow and 4 goats was enough to compensate the defilement of her 6-year-old girl. And she could no longer pursue the case. She has no economic power. She's considered to be subordinate to her husband, and so she cannot pursue this case on behalf of her child. And apart from that, the compensation went to the father of the victim, not towards the victim, not that it would make it any better, but it went towards the father of the victim because of the perceived loss of dignity towards the father of the victim. And had it been a married woman, it would have been towards the husband of the victim. So I feel that these TDRMs, even as we are congratulating ourselves from being emancipated from our white colonists, we need to actually be very, very careful in how we are treading towards, access to justice. If this 5-year-old girl cannot access justice because her parents have already decided on her behalf, she does not have consent to decide on her behalf what system that she would like to, evoke, then we are actually impeding her from her right to access to justice. Lastly, I also look at the issue of, just a lot has been spoken about this, but the backlog of cases, how we can improve that. And my recommendations, as I finish, is that we need to evoke the Victims Protection Act. And I love this act because it attempts to bring we've talked about retributive justice and the need for compensation side by side, and what this act attempts to do is to bring the remedies which are normally offered within a civil court setup and brings it to the ambit of a criminal court setup. And unfortunately, from what I've seen, a lot of prosecutors are reluctant to evoke it. When you do evoke it, the funds have issues and so on. But I believe that this will be something which is the blow to this issue of TDRMs being used in matters which I deem are rogue in a lot of instances. Of course, there's the issues of legal aid. We need to provide that, especially in consideration to the non-offending parent, towards usually the mother of the victim. We need to recognize that the mother of the victim can actually, usually, it can also be the father, of course, but just the non-offending parent, we need to have that consideration so that we also involve them within that system. And I think I'd like to mention, lastly, this ruling by Justice Mary Kasongo of the High Court in Nyanyuki. And she made what I hope will be a case which will create a lot of precedent. And in this case, she ruled that the caregiver of a child, the case concerned a house help who knowingly concealed the sexual offense of a child. She was not the direct perpetrator, but she knew about it and encouraged the child not to say anything, did not tell the parents. And the justice actually recognized her as a secondary perpetrator and stated that she helped in concealing the crime and aided and abetted the crime. And for that reason, she was given 2 years. And I think those are some of the issues that we really need to interrogate in as far as what kind of balance can we create so that we ensure that even as that parents who have a duty under the Children's Act, under Section 23, to protect their children are actually doing so, and that they are, that the issue of protecting their children includes even a duty to report. And when they do not report, how far can we hold them accountable for non-reporting? Yeah, I think that is it in a nutshell.
Thank you very much. There are a number of terminologies you've used. You've talked about the need to interrogate customary justice systems. You've talked about the need to be wary of idealizing traditional justice systems. And you've also talked about the importance of having human rights standards. And I just would like to throw a thought. When we talk, and I'm now going from where Jemima left, where she talked about the hierarchy of laws and how customary law is usually at the bottom of the pile. And the question as to whether, when we talk about interrogating customary law, we were also talking about interrogating introduced formal law. And and then the question, going back to what people are talking about, repugnance to justice and morality, asking the question about whose justice, whose morality. And asking those questions without having any lenses that we are wearing, so that we basically, I personally use the term engage. rather than interrogate, because interrogate has connotations of being up here looking at what people are doing. And then finally, just on that whole question of the interplay of how can we, as people in justice sector, make access to justice not arduous. And I speak having talked to very many women in Kibra who are talking about post-election violence. And for many of them, they want to forget because you raise their hopes. But the wheels of justice move extremely slowly. And for many of these people, even the fare to where you're being told you can get the P3, or I think they've now reviewed the form. How do we make access to justice for persons who are violated, especially sexually violated? Because you see that is a very, it's your persona that has been attacked. How do we help them access justice without re-traumatizing them by taking them through the ordeal? And for Chantal, I'd like you to read a paper by Celestine Nyamu Musembi, writing about this push and pull between these two systems. It is titled Pulling Apart. And it actually looks at the provisions of CEDAW and the Maputo Protocol. And the question about how are we going ahead with the rights of women, and what are the things that, it's almost like, you know, the chicken which is tied and thinks that you can move, but then you're still being pulled back. And how do we ensure that at the end of the day, justice is delivered? So we'll go to the next presentation. And the next presentation is by Betty Okero. Betty Okero? Is she here? Oh. Her presentation is virtual. Why is it not? There is no signal. Can we go to Mary Mwangi as they sort that? Can we have Mary Mwangi as Betty Okero is sorted? Mary Mwangi? Yeah, here you, on provision of legal aid services through alternative justice systems.
Thank you. My name is Mary Mwangi, and I'm from a very rare profession that we are, I think, maybe 0.0% 0.1% in this room, because I'm a sociologist, and currently a public administrator working at the County Commissioner's Office. I'm happy to be here, and I want to say that I want to take you back to our villages, whereby we have the national government administrative structures that is taking care of the 90% that we have been talking about, plus other leaders that we have there. I think I want to state that I know in public speaking, because I also do public speaking, it is said that it is very hard to keep people listening to your presentation, especially when you do more than the 7 minutes that the professor talked about. In fact, a study states that 28% of the audience are either reading SMS, 27% emails, 17% falling asleep. The others, that other percentage, is doing a mixture of things. For example, they are thinking about checking out of Centrim. So welcome. Kindly come over, my technician kidogo. I want to go back and state that I'm looking at the role of national government administrative structures in provision of access to justice. And we know much has been said that access to justice, just go next, the first slide. That is the role of national government administrative structures in okay, thank you. And access to justice, we know that it has been said is a basic principle of helping people, especially in the rural areas. And estimated 4 billion people around the world, they live outside the protection of law. These are majorly the poor and marginalized people within their societies. And we know that access to this is challenged because especially we have long distances to court, that has been said, and the cost of filing the cases in courts. In the first day, we heard of the number of judges that we have and magistrates as compared to the population that the courts are supposed to serve. Now, several articles of the Constitution have been mentioned by the previous presenters. And my paper focuses on that despite the Constitution's support for the AGS system, the courts have remained to be Kenya's preferred option of resolving disputes. The poor Kenyans, they still feel going to court is where justice is. And that is why we have 10%, 90% in the villages where the chiefs and the administrators are. The low uptake of the AGS can be attributed to limited awareness of the process. In fact, we have very, very naive citizens out there. They don't know. I had one of the advocates talk of a case where he was trying to refer the parties to the chiefs to go and agree, and they said, no, we are going to pay you as an advocate to offer some guidance on land succession matters. And despite we have the limited awareness of the process, then we have the less number of professionally trained persons in AGS, especially mediators. Administrators are, according to me, they are, if trained well, can be perfect mediators, because you've seen all over the country, like Kenya, where we have cases of land disputes in Molo, where we have one community versus another. Finally, we end up mediating, whereby now you have the peace elders. We call them now under the tree the whole day, and we come up with a peace deal that restores peace within those structures. So it is against this backdrop that we have very limited structures, even in the policy for the AGS. And this paper proposes that grassroots national government administrative structure, and grassroots in this case, I state, we have the structure where we have the county commissioner on top, according to the National Government Coordination Act. We have the deputy county commissioner in charge of a sub-county. We have the assistant county commissioners, and down, my focus is on the chief, assistant chiefs, and the local elders, wale wazee, wale wa kijiji wale, where our parents live, because most of you live where the elders are not, but where back in our families. So these structures, according to me, they can play a role in enhancing access to justice by providing effective and efficient alternative justice system. That is, I'll move on. I did administer some questionnaires to some chiefs in Nakuru North Sub-County. This was because I've been involved with the Faculty of Law Legal Aid Project, Egerton University. I've been helping them to mobilize community forums. And it's a very proactive sub-county in terms of where Egerton has been able to deliver legal aid clinics. There is so much demand in that sub-county, I think because of community awareness. And I wanted to know now, what kind of these disputes do the chiefs solve? What do the disputants feel? The ones who have had cases resolved at the chief's offices. So I administered some questionnaires to the chiefs, assistant chiefs, and some disputants, about 39 of them, 39 chiefs and assistant chiefs, and about 24 parties who had taken their cases to court. You can see that is the nature of cases that are solved at the chief's offices. Kindly check on the chart. We have marital disputes at 47.8, debt cases whereby nimekukopesha pesa especially because of corona, because this was done within the corona period, umekataa kulipa, na si kukataa, it's because COVID hit us and so I don't have money to pay you. So these are minor cases. We have LAD at 17.4, theft and fights. I know for the advocates and the magistrates maybe who, for some of you, these could be similar cases that you have. To decentralize this, because some of them now, like for example, theft or fights, where you even fight brothers fighting for land, brothers fighting for some minor issues. Must those cases go to court? No, we have mechanisms on the ground. Then, sorry. Okay, all these are for the cost. The cost is relatively low. Actually, because I did a question on that, I wanted to know, are they charged? And I realized, though our chiefs tell us we do not charge, but they explain, I have some elders, because I have some elders that about 4 or 5, and they are not paid. So they are the ones maybe who asks the disputants to, because literally it is supposed to be free service. So they will not tell us that but they say the elders, they did not have anything, so maybe they asked them when they were going home, and the disputants were telling us the average cost came at around 500 shillings as compared to the ones who said they have filed a case in court, which was about 6,000. That you will find in my full paper. The procedure to solve the dispute is whereby a party presents a case to the chief, or to an elder and is referred to the chief, or from a church minister where they go to church and they complain, and the reverend or the father realizes this one can be solved by the chief, so they are referred back to the chief, or vice versa. They can be referred from so many places. So the chief appoints some 3 or 4 elders, 3 to 5, that was the mean from the respondents. And then they are given a day where they come and either the chief will summon one of the parties to come and give the side of the story. On a different date, summon the other party and then reconcile them. That is how they explained the disputes were solved. And this is a perfect case of mediation. A professionally trained mediator, this is how they also do the cases. I'm also a trained mediator, and that is why I felt if we can pick up this discussion even to our chiefs, they can be able to resolve some of these cases even before they come to you. So the procedures are almost the same with mediation, arbitration, and other forms of alternative dispute resolutions. So the next one, on key features that I noted, the language is very flexible, it is very fair. Actually, the respondents, the disputants stated that the parties use language that they are able to understand. In fact, in most cases, they use the local language. Unlike you advocates in court, you have to look for an interpreter. The court has to appoint an interpreter. So they are able to express all their emotions. You know, you cannot express emotions in English. But in your local language, even Professor Mbote here, she will express as a local woman and she will be healed. That is the issue of alternative justice system. You know, you restore justice both for the... so that is it. And I found out that the panel, the parties can switch between languages, where you have, especially in town, they can be able to switch. You have them switching from one language to another. On fairness, 97% of the disputants indicated that the process was fair. All parties were given equal opportunity to present their side of the story, and all parties were treated as respect. That's what they responded. And the remedies are, they said that it is reconciliatory because it is a win-win situation. It's not like court whereby you have a winner and the other party leaves feeling they have lost. In the case of marital conflict, because actually this is the highest, the disputes that chiefs and administrators solve, they said that the parties are made to see their mistakes. The offender parties are asked to apologize. Kama ni mama alikuwa amekosea mzee, ama mzee, it's very hard for a man to say sorry, but now chief anamwambia, sasa si umekubali makosa, sasa ambia mama pole, and they go home when they are together. So the offender, in case of related debt, the parties were asked to agree on payment schedule, which is very flexible. Utakuwa unalipa kiasi gani, mimi nitalipa 200, like that. And they become so honest, and they're able to clear. Now, the challenges that we noted, both on the chiefs and the assistant chiefs, training. We only have 42% of them have done some form of training in dispute resolution, with only 8% who have undertaken comprehensive course that go for 1 month. So why you see maybe chiefs doing some mistakes there, especially advocates, have been caught by several advocates because of our chiefs. So I know what I'm talking about. Only a percentage of them have been trained professionally on how to resolve conflict. So going forward, if we recognize that there can be another form of AGIS, are we able to come up with a training manual, the Council for Legal Education, for those chiefs, for those grassroots administrators? Now, so that is one of the challenge. Then the other one is on lack of legal framework. Most administrators, they only rely on the penal code. Actually, chief bado anasoma ile penal code. They are not able to read so many of the new reviews that you have been able to do in law. But if taken through an extensive training, they can be able to come help in solve some of these many disputes that are in court. There is also no framework that defines the process of resolving dispute. Every chief determines, okay, the nature of this case, this is a large case. I think if I summon the party, the other party, they are likely to come up with a solution. We don't have a standard way, and that's why we were saying, if we have a chief in Pokot and another one in Nakuru, another one in, do we have a standard guideline on how they can solve this dispute? Lack of resources. The elders, as I indicated to you, they are not paid. So how they survive, they offer maybe that free service to the government. I don't know how free that is. Lack of cooperation, especially from people who feel they are losing also, and from politicians. In conclusion, the national government grassroots administrative structure, it offers a viable means of providing access to AJS, and these structures are already widely used. Already they are existing to resolve family and civil issues, as well as petty crimes. And as I stated, they are shorter, there is short duration of solving the cases, the lower cost involved, transparency, and perceived fairness, and restorative remedies. Now, the government should provide training to the administrators so that they can be able to deal professionally in solving those disputes, the many disputes that we talk about. Key issues, as personally, I'm advocate for mediation. Mediation and arbitration, those two. About traditional form of justice, as Madam was stating here, that one, it's not necessarily. It needs to be looked into so much and to see how it can be incorporated into the other forms of justice. So I state that the solution of the few judges and magistrates, advocates in rural areas, we have national government administrative structures. Thank you so much.
Thank you. It's interesting that you say, Judge, that the chiefs don't have a standard way of resolving issues. I remember FIDA reporting how when women were reported by their husbands to the chief would actually flog. He would whip them. And they'd tell them, when you go back, don't repeat what you did. So in essence, you know, that lack of structure can also be problematic. That's why it's important to have structure. So we are now having Betty Okero, who is online. She's not there. Okay. Okay, and we'll have the next presenter as we look for Betty. And please fill the evaluation forms so that we give feedback on what is happening. Who's collecting that? And there should be somebody collecting the ones that have already been filled. So the next presenter is Patrick Washira. Is Patrick Washira here? Patrick Washira, you have 7 minutes.
All protocols observed. I'll probably an intro of myself. I'm a state counsel working at the Attorney General's office. I work at Mombasa, and basically in charge of the coastal part of Mombasa. And my part of what I do every day is about litigation. How do we enhance litigation so that we can have access to justice? The focal point of where we start litigation, we start it at our desktops, at our offices. How do we then ensure that that practice that is there on our desks actually facilitate and enhances justice to all the...
Mr. Washira. So you need to...
Oh.
The microphone is off, but if I am struggling to hear you, then the people at the back won't be hearing you.
Thank you. I'll try to be more louder. Thank you. I hope you heard my introduction. I'm a state counsel working at the Attorney General's office, and what I do every day is about civil litigation, court practice, and within the civil law framework. How do we ensure that the counsel who is doing his work is well prepared so that he can then make a good paper, a good presentation in court, and in all those frameworks, there is no way counsel will walk into an alternative justice system and make a presentation of that widow, of the small girl or the small boy whose rights have been trampled upon if that counsel was not efficiently prepared to make that presentation or defend that justice of that vulnerable person. I will not belabor much about the constitutional provisions, about Article 48, Article 50, and Article 48, access to justice, Article 50, all the rights for a fair trial and hearing, the right for counsel, and again also Article 149, Article 159. How do we ensure that technicalities in all their senses are evaded and are removed from this counsel who is preparing to ensure that he firmly represents an individual in colleague, a big state corporation, but for this issue now is about that small person. How do we ensure that counsel does that work in that sphere? We also are guided by the SDGs. Article 6, Goal 16 is about access to justice, ensuring it's effective, ensuring that it is accountable at that level where the counsel preparing the case it actually makes a good presentation before the judge, before the tribunal, and where justice will be delivered. My hypothetical question is that is there a correlation between the practice of law when we enhance it and the delivery of justice? If we sufficiently empower counsel, if we sufficiently empower the defender of access to justice, simultaneously we shall ensure that there is access to justice. It is not automatic, but we should look for ways of ensuring that we develop jurisprudence. Majority of the lawyers in Kenya, majority of the practitioners of law in Kenya are modeled in a way that their main area of practice is within their law firms, and then within that sphere of their law firms, how do we ensure that the counsel gets the best that in terms of access to clients, in terms of ensuring that he creates time for pro bono work, and then simultaneously, and obviously then there will be an access to the justice system because the counsel is better able to advise a client. What are these challenges that counsel will at the first instance need to encounter and then need to limit these challenges that are there? The main aspect is that our bar is more entrepreneurial. It is headed whereby the time factor has the time or the seconds or the minutes that are spent on a litigation brief have to lead to resources and unfortunately, then that leads that the time that we spend nurturing the young counsel, the time that is spent preparing for the case has to have a time factor on the revenue that are generated by the bar. Sorry, by the individual counsel. It therefore becomes more expensive to have time for this lawyer. That lawyer will not have time to share with the with the vulnerable in the society. Is it possible to have that, to have this lawyer time scheduled in a way that there is work for pro bono work, there is time for pro bono work that that he will always have, that he will always create time for? Do we have plans for our law firms whereby they are created in a way that the strategic plans that we have for our firms for 5 years, 10 years, that we have sufficient time to represent these people who are marginalized in our society, those people who are affected by gender-based violence, those people who are affected by the electoral violence that we see, these kind of electoral offenses that take place. To what extent will that lawyer be sufficiently empowered? We also need to look at our access to court system. Access to justice should actually be interpreted or looked at within a sphere of access to courts. The physical access to courts. Physical access to courts, our courts are intimidatory. The practice that we have developed, this kind of common law practice, whereby procedure means so much, to an extent that that person who comes to court without knowledge of the procedure is intimidated. That person who comes to court on a wheelchair and not able to go up the stairs leaves the courtroom intimidated, and next time that person will shy away. Look at our court physical structures. The old law courts here at Nakuru, at Mombasa where I practice, maybe even at Kericho, Malindi, all other places. When you look at an old lady going up the stairs, I'm sure she'll not come back. Why? She has not been inspired to pursue justice within this framework. And as a result, what Mary just made a presentation on, she then has to relegate herself to presenting her case before the chief. What are the kind of improvements that we can make to our law firms? Simple investments on matters of technology. Simple investments on matters of benchmarking. There was a presentation on the monitoring and evaluation aspects. We really don't conduct those to our law firms, to the legal practitioner who is preparing for his case in court. As I look for time is far much gone. As I look at my watch, time is far much gone. What are some of the recommendations that I can make? Ensure that we have proper implementation and assessment tools. What are the benchmarks that we have created for our firms? What are the targets that we have created on our firms? How many minutes and hours in a week or in a month do we create for pro bono services? How many times will the practicing counsel go or walk to the jail or to the prisons to see that he has a chance and time to talk with their clients who expects that next time they will be there? I've seen it severally in court, although nowadays it's virtual. When the offender that lawyer obviously then never spent time preparing for that brief, and I'm sure it will not be rosy during that whole trial process. We should also enhance eligibility for legal aid. Who is eligible for legal aid? Let us not look at it just from the vulnerable. In the full paper, I noted that the views that I collected ended up that we need to have those people who are suffering for small rental payments, those people who are suffering for just ensuring that their children have been locked out from smaller abilities, from small access to their who are eligible for legal aid. Let us try reduce the procedural technicalities and that are there in court. Let us look at a way in which that judge or that magistrate looks at that case where there is that person who has low chances of access to justice. Let us look at how we can reduce their technical aspects on their understanding on matters of justice. Let it be looked in a way that they will not be seen to be too technical and procedural on them. Finally, our court justice system should also probably consider that how do we motivate the young ones, the young lawyers, so that they can pursue legal aid? How do we ensure that students participate even at the court level? A small person who wants to file a plaint in court, do we have a model form which they can fill and then let it be a sufficient case in court? A small application. Do we have ways in which the universities can collaborate with the courts so that we can ensure that at least probably there is even a computer available to help fill a few forms, to help make an application, and then that person who is not ably represented by counsel have a chance to articulate their matters before the law. And those small opportunities here and there are missing to create avenues for access to justice, especially starting right from our chambers where we prepare to go to court. Thank you.
Thank you, Mr. Washira, for reminding us of our duty to keep the doors of justice open. Is Wairimu Gadhi here? Huh? So Alvin Kosgei, I'm told, is here. Alvin Kosgei, is he coming to present or he'll present from there? Okay. So can we have Wairimu present for 7 minutes as Alvin moves? Oh, Alvin, you're here. So you have 7 minutes, Alvin. Yeah, brevity is the soul of wit. Yeah. Okay. So Alvin was in the earlier session, and his presentation is on access to justice and institutionalization of traditional dispute resolution mechanisms, lessons from South Africa and Australia.
Yes, good afternoon, everyone. As you've been told, my name is Alvin Kosgei. A bit late, I should have presented a bit earlier. I don't know if I can be helped with this. Yes, we can hear you. Okay. Yes, so my paper focuses... Okay, thank you. My paper focuses on the institutionalization of traditional dispute resolution mechanisms with a focus on the experiences that we can learn from the context of South Africa. The background of my paper is that the Constitution of Kenya 2010 enjoins the courts and policymakers to consider or find ways through which we can utilize traditional dispute resolution mechanisms as one of the forms of ADR to facilitate access to justice. That is found in Article 159 and Article 67, which establishes the National Land Commission and gives it one of the mandates of ensuring that TDRM is employed in the resolution of disputes related to land. My conceptual framework is based on the theory of decolonization, and it focuses on the challenges that post-colonies have faced in trying to ensure that their citizens access justice as provided for under Article 48. As we well know, that decolonization, beyond being a theory of how colonies take back their governance and political systems from former colonial masters, decolonization in recent times has moved to how these countries can find ways of changing the institutions, education systems, and economic patterns to reflect the realities of the people and the traditional ways of life that were there before the advent of colonization. There are many things that are discussed in my paper, but I will not dwell too much there, being mindful of time. Save to note that this theory of decolonization, many scholars, including Achille Mbembe, the Cameroonian scholar and a sociological professor, focuses on how Africa has been viewed in modern discourse as a reflection of the other in relation to Western ideas of civilization. Other than Achille Mbembe, we know our very own Professor Ngugi wa Thiong'o has written about decolonization in the context of language and says that we need to decolonize how we use language because language is a carrier of culture. Other than those two, we also have Vandana Shiva, who focuses on how these new strands of decolonization move beyond the political systems, move beyond the economy to how we can look for ways to adopt our traditional systems in areas such as plant breeders' rights. But I'll move on to the next session of next part of my presentation, which is how traditional justice systems are useful in ensuring that there is access to justice. Tanja Chopra, writing in the context of Northern Kenya, says that the people of Northern Kenya have chosen to use traditional justice systems because the state justice systems are either inaccessible or they would prefer to use their traditional justice systems because of ideas such as restorative justice and cultural inclinations of the people. That being the case, it being the case that traditional justice systems are more widespread than the state-funded justice systems, it would be important to find a way through which the government, together with the policymakers, find a way through which we can use the traditional justice systems, which are more accessible and more acceptable to the people, to facilitate their utilization in the access to justice. And as I've argued in my paper, access to justice goes beyond, I don't know if I can get water. Access to justice goes beyond, thank you. So access to justice beyond it being the right of the citizens to be able to access courts also refers to the ease through which people can make use of the law, the means through which individuals can have their rights which are enshrined in law activated and actualized. In the context of South Africa, there is an act called the Traditional Governance and Leaders Act, which provides for mechanisms through which traditional institutional structures of leadership and governance can be recognized in formal law. Under Section 2 of that Act, it is provided that traditional leadership and governance mechanisms are recognized formally in law. And if you've had a chance to look at the South African legal regime, the traditional governance systems are actually enshrined in the Constitution. This is Article 211, and it is provided that these institutions and governance structures ought to be used and utilized in the governance of the society. Now, the Act is based on that Article 211 and provides for recognition of, one, the traditional society as a society in itself, And number two, the requirement that these societies come up with their own governing councils, which governing councils can do, among many other things, resolution of disputes that arise among the members of those communities. The way the Act is structured is that the provincial states are required to recognize these societies, taking into account whether or not they rely on their customary law in their governance structures, and whether their history has proved that, has shown that these are people who rely on their customs in their governance structures. So other than the recognition and the requirement for formal law and formal political structures to establish them, to recognize them, and gazette them, there is also, in part of the institutional framework, a commission then which determines or regulates or looks into the issues that may arise among or inter the communities. There is inter and intra. In the communities, there is a customary law and the traditional customary institutions that these communities have had as traditional indigenous communities. Then in the cluster of those communities, there is a commission which determines whether or not what the provincial council, provincial house, which recognizes them, has done it in the right way or not, and if there are intercommunal disputes, this commission also is given the mandate to resolve them. So in essence, the proposal of my paper is to look at what South Africa has done under the conceptual framework of decolonization, and decolonization being beyond the idea that decolonization ends at the time we take political power from the former colony, to trying to modify our institutional structures to reflect the needs, the ideals, and the lived realities of the people. The final section of the paper looks at how the lessons that are learned from the changing times can be, so to speak, incorporated in our legal system, and it is proposed that perhaps, since the recently launched access to justice, not access, alternative justice systems policy is wide and looks to cover the entire groupings of alternative justice systems, it is proposed that if it's possible, either under reviewing that policy or coming up with a specific policy to deal with the issues of traditional dispute resolution mechanisms, we can have a policy that speaks to those things, which policy can be used to inform legislation. And part of the issues that the paper recognizes as being key and central to such a proposed policy would be a further recognition of those communities and coming up with clear-cut structures and mechanisms of determining that certain communities are traditional. The other proposal relates to the role of county government. We know that county governments are closer to the people, and that being the case, they are more alive to the intricacies and the needs of those people. And that being the case, they can be given a role that is akin to the role given to the county governments in the context of the Traditional Knowledge and Cultural Expressions Act, which gives county governments the mandate of coming up with I can say, so to speak, of the traditional knowledge and cultural expressions of the people in that community. In the same way, we can have the county government being given the mandate of determining, recognizing, and enacting a county government law that provides for those processes. Of course, the sticky point relates to the so to speak, the repugnancy clause that has been the subject of various academic discourses. And I think the paper of Francis Kariuki with respect to customary law jurisprudence in the country is quite instructive in this note that That clause should be interpreted in a manner that is facilitative other than a manner that is restrictive. And to cater for the various interests that might arise, or the real or imagined interests and discrimination that may arise in the context of traditional dispute resolution mechanisms, the policy can provide that the TDRM tribunals, in quotes, must comply with certain bare minimum constitutional standards provided for in the Constitution, including the gender rule, including the need for special interest groups to be catered for. And the other interesting thing that I saw from the Traditional Governance and Leadership Act of South Africa is that, other than accepting the customary systems the way they are, we modify them a bit to reflect the reality that customary law is dynamic and changes with the times. The pressures that come with the formal law, the changing cultures that come with adoption of Western culture and such like things. So to cater for those interests, the traditional dispute resolution mechanisms and the policy can be crafted in a way that it ensures that those interests are provided for. I do not think I would wish to tire you more. Much more is said in the policy paper, but I will ask to stop there.
Thank you very much, Alvin. I think a discussion on you can actually rest, decolonization, and expanding this beyond the remit of what we are discussing here, because the work of Achille Bembe, the work of Ngugi, the work of Vandana Shiva, they deal with a whole host of issues. And there's also a revisiting of this whole question of repugnancy, which now speaks to the need to be a little more nuanced when we talk about repugnant to justice and morality, and also to think about decolonization, as I think he's brought in the fact that decolonization is about power. So that, again, is something that has come out there. And also the fact that in South Africa, they have a regime for these traditional systems. And I remember when I learned land law many years ago, there was the Magistrates Court Act. There are people here who learned that land law, who will remember what was happening then. And you know, it's almost like we moved away from it, but now we are coming back to it. And because we have this Community Land Act, how is that going to be speaking to traditional access to justice within traditional justice systems? So now we'll listen to Betty. She is with us virtually, and she'll be presenting on ADR, the weak links in the letters settled debate, and the role of discretion in the access to justice. Betty, you have the floor.
Thank you very, very much. And I'd like to say hello to everybody, those who are online and of course the ones in person. So my paper really is about how ADR has the intention of having ADR with a view to resolving. And yet that resolution doesn't perhaps take into consideration a number of issues that I think are very pertinent. That the structures that we have right now are not governed. We have a policy, but there really isn't a very clear guideline as to how those processes must be managed. And that if we keep talking about the traditional way in which we used to do things, then we must also recognize that that traditional system was actually considered very free, very fair, and very equitable. and that ultimately those solutions were considered as win-win. So it wasn't that there were combatants and there were losers, or there were winners and losers. It was that people went forth and said, we agree, and that the decisions that are made are acceptable, despite who would be considered to be the loser. Now, even as we're encouraging ADR as an alternative form, we have not put in place the necessary effort that should make them fair, that should make them accessible, that should make them effective. We haven't recognized that there are so many of those structures in place, and that there's a tendency for people to actually start playing with those structures so that until they're able to get a favorable resolution. And that in communities right now, the assumption is that if we're talking about ADR, then we are talking about the chief, the provincial administration. Or if it's not them, then we have other structures like the community policing committees or the peace committees that we have in the community. Or even then, we have got the offices of the police, or we go to civil society offices, or we go to the church. There are so many of those spaces, and yet none of them have guidelines to be able to ensure that the format or the process that people are engaged in that leads to a letter settle is considered fair. Because unless we take into consideration the most important aspect of this, which is process, it therefore means that usually the outcome may be considered flawed. And it also raises the question as to how that outcome can actually be enforced. So my paper is trying to advocate for the need to be able to put in place guidelines, that we need to have harmony, that despite having all these many structures that we talk about, recognizing that cultures are different and recognizing that communities have put in place different institutions, there has got to be some clear guidelines that manage the process. That if women, because they're the ones who usually go to these spaces, that if women go to these spaces, that the information that they give, their truth, is not readily dismissed on account of culture or on account of whether they have the money or which community they come from, because those continue to affect some of the conversations that happen spaces. I mean, we have worked under the program with Kenny on the ADR process, and we have seen, elderly people who are about 50, 60, 70, engaging with people who are about 30. And for some of them, they find that extremely uncomfortable because they're not able to share some of the sensitive issues that they have, especially where it is marital in nature, or even when you're talking about land or the family conversations that go on. And so for me, age is important because a number of people then do not go to those spaces because they feel that it is embarrassing to share what they want to present in the spaces with people they consider their children or their grandchildren. So we need to be able to ask ourselves, how should these structures look like? And are these structures only about mediation, arbitration, and reconciliation? What happens to after the event? What happens to enforcement? Because that has turned out to be an extremely weak aspect. And what happens to ensuring that those resolutions are considered legitimately and valid? Because traditional systems, it was easy for you to finish and move on with it. But the now we are witnessing is that even where people have settings and they have a process that they're calling mediation and that they have these resolutions, enforcement becomes an issue. That you will find that the party who is aggrieved has to continuously make regular visits to be able to complain that when we agreed and how we agreed, it's not happening. And at some point you find that, especially where the chiefs are the ones who are concerned, they sort of lift their hands up and say, at this point, there's nothing for me to do. We have to take the matter to court, which therefore means, how do we make sure that one doesn't have to move from an ADR, a structure in the community, to court, but that we find out how the court can move to these structures to be able to validate some of those rulings. I personally think, and I believe, that those structures are important and that not every single conflict that we have needs to go to court. And that because one of the things that makes them attractive is because people consider them as providing instant justice. I personally think we need to be able to improve those structures. The ADR policy that we put in place needs to be actualized, but it also needs to be pragmatic and practical. And the policy as it is still, somebody the other day said, very anecdotal. For us to be able to make it a reality, we must be able to put in a number of the best practices that we can get across the country to be able to provide the necessary guidelines that will make these structures much, much more accessible, available, and conclusive when it comes to the rulings that they're giving. Because for me, like I mentioned, that an analysis of the outcomes that we have seen given, the biggest challenge is enforcing it, which therefore reinforces the aspect of where people then do not consider some of these structures as having the power. And therefore, people sometimes tend to jump and say, they are not going to be able to resolve it permanently. I will move to the next. We have got to be able to find out how we're going to make the structures much, much stronger. And then, of course, it then begs into question, what then becomes the responsibility and the mandates of some of the duty bearers in the spaces? We have got the 10 houses, the Mijikumi. We have got the chief. We have got the chairpersons of the Peace County forums. What is their mandate and what is their responsibility? I believe that the role of the chief should be, outside of creating this space, provide an avenue where people can meet and mediate on their issues. I think that the other role of the chief should be in enforcement. And that in the absence of that enforcement, then we have to find out whether we take this to a higher level without necessarily negating the conversations and the resolutions that were made and the agreements that were agreed upon. I also think that in these spaces, we've got to find out how the court mediators can find their space themselves in those spaces, because they then will be able to add a level of legitimacy. I think in these spaces also, we must be able to have the HRDs or the paralegals that we have in the communities. We must be able to document those processes. But apart from that, we provide oversight to ensure that there are certain standards that are maintained when it comes to having certain hearings. Civil society must find their place over there. We then must be able to ask ourselves, because we've been discussing so much about legal aid, how then do we allocate certain resources to ensure that these structures become sustainable? Or are we saying that legal aid can only be provided if we are talking about legal support? Can we then become a little bit more creative in how we are going to use those funds to also be able to strengthen those structures? The other aspect for me is when we have such an integrated group in an ADR structure, you then are eliminating, the whole issue of people jumping from one to the other. But apart from that, we are then saying we are legitimizing a structure that is recognizable, that is allowed, that is valid to be able to carry out the work that they're doing. And that whatever resolutions that come out of here can actually be registered in court as a valid resolution. And that following that, the question is, in the event that that resolution is not followed through, or in the event that the warring parties fail to implement the resolution, then what is the role of the court coming in to then take it to another level without negating the activities or the actions that have already taken place before? Thank you.
Thank you very much, Betty, for a very crisp and concise presentation. I think she's challenged us on structures for ADR, enforcement of the resolutions that come out of ADR, but also the validity of the resolutions. And there is also the question of, in this ADR, whose truth is the truth that is actually put forward. So thank you very much. Again, if you have questions for Betty, put them down. Now we are going to go to Wairimo Gadi. Your 7 minutes begin to run Now,
I hope you're on. Thank you. I noticed that I'm speaking a few minutes to lunchtime. Therefore, I'll try to be very short and crisp. Thank you. Or as the youth would say, short and sweet. Now, Mr. Washira asked how we can empower the young advocates. And I think that's pretty simple for me. Tuongezeni pesa. As I've read somewhere, there's no bread too hard when there's tea. Now, much has been said, and a lot of experiences have been shared by the speakers who have spoken here. I'm therefore excited that I'm going back home with a wealth of knowledge. For those visiting out of town, karibuni Nakuru. My name is Werimo Gadhi, a practitioner in these local streets. Nakuru County is big. Now, I shall endeavor to be very short because everything has been said and a lot has been covered. Now, we can all agree that legal services is a complex creation and it's extremely hard to acquire. We can also agree that the very courts of law and justice systems are especially difficult to navigate. Now, this is especially true for the poor, being both the accused persons and complainants. We're also talking of children, being children victims and also children in conflict with the law. We also have a lack of legal awareness and information, gaps in the system being corruption, lack of adequate explanations. This is especially true during plea taking, where you find that an accused person has not understood what has been read, and they end up pleading guilty or not guilty, depending on the gravity of the offense. We also have situations touching on treatment of persons with disability. Of importance is Article 28, whereby they have the right to be treated with dignity, and also at Article 54(1)(a), whereby they ought not to be addressed in a demeaning manner. Of essence, touching on children victims and children in conflict with the law, I'm reminded of Constitutional Petition number 1 of 2017, whereby the issue of discrimination was raised pertaining the accused person who was feeling they were being discriminated against as compared to the minor victim. This one touched on the issue to do with the lack of consensual sexual intercourse among minors. And it was held that really it's an issue we ought to revisit and rethink. And from where I stand, I believe it's an issue that also falls under the realm of legal aid and access to legal information. Notably, only a tiny proportion of Kenyans requiring legal services are able to access these services. This is because lawyers are either unavailable or too costly. Now, a sound and successful legal action aid plan is one that is tailored to ensure that all citizens receive fair and equitable access to justice regardless of gender, position in society, or religious inclination. Now, this includes legal information. For example, a lot of litigants are not aware that they have the right to have their cases heard in camera. This is particularly true in sensitive cases, say divorce, custody, or even touching on people with mental and other disabilities. Now, there's also the issue of representation in courts. We have the issue of psychological support and also re-entry of persons back in society. Now, this final limb is one that has been overlooked. In essence, when somebody has been released from the correctional facilities, they're expected to join society without having support to have them re-enter back to become law-abiding citizens. Now, legal aid has been earmarked and emphasized by the United Nations Principles and Guidelines on Access to Aid. This was done together with United Nations Office on Drugs and Crime, whereby it was emphasized that access to aid is an essential factor in a fair, humane, and efficient system based on the rule of law. Now, UNDP initiated a study in 2014 and advocated for inclusive societies whereby justice is enabled for all. Now, a number of complaints that are raised and which we come to interact with under legal aid, one of the practitioners, a pro bono advocate, is discrimination, torture. This one is especially true when they are reporting crimes or at the point of arrest, unlawful detentions, coerced confessions, and wrongful convictions. Now, notably, early stages will impact the person and how they perceive the justice system in general. This one is especially true at the point of investigation and at the point of arrest and really before plea taking. This has been especially true of late during the COVID pandemic, and you've heard that there have been a lot of infractions touching on the 24-hour rule. Now, this is not just in criminal matters. We also have issues touching on marital and custody cases. What comes to mind is a few weeks ago, should be 2 weeks ago, I witnessed a situation in court whereby a 6-week baby girl was handed full custody to the father. Now, this has been enabled because you find that the person, let's call them the plaintiff in this case, approached the court under a certificate of urgency. So in that case, the respondent does not have enough time to either procure counsel or prepare for trial. So at the time the matter is coming to court, they are manipulated and unable to understand what is happening. In this particular case, it was really sad because the lady was unable to address the court. It was really emotional. And by the end of the day, the directions issued was that full custody goes to the father pending the hearing and determination of the suit. We all know how the justice system works. Pending the hearing and determination of the suit, especially in custody matters, might be until the girl is 18. There's also issues to do with labor disputes and also property and inheritance cases. In this final limb, it is not unheard of, whereby widows in Kenya are evicted from their properties once their husbands pass on, and relatively very promptly pounce in to lay claim on the property of the deceased. So really, we are in a situation whereby legal aid and access to legal information takes a central role despite having structures in place. For instance, we have the Legal Aid Action Plan. We also have the UNDP Principles and Guidelines on Access to Legal Aid, and we also have the National Legal Aid Act of 2016. We are not short on provisions. We just need to address the gap in the actual delivery thereof. What then are the recommendations? When these people come to us, then we should be able to tell them their rights, educate them as to how to navigate the procedures especially, because it's one thing to tell a person what their rights are, and it's another to tell them how to enforce them. They need to know where to go for assistance. We need to get them the help that they need. We also have to ensure that there's increased follow-ups. I remember, Prof, you said that we are in a situation whereby we give them information and we give them their rights. They go home having raised their hopes, only to get into this thing itself and find out that that's the end of the road. So it's one thing to educate, it's another thing to follow up. There's also the requirement for training of legal aid providers. And this is especially true in order to suit particular requirements of a particular client, be it a child, a victim minor, or a child in conflict with the law, a woman, or a person with disabilities. In penning off, I would say that at the heart of every free nation lies a robust legal system whereby rights can be enforced and justice served in a manner that is fair and equitable for all. Asanteni sana, happy Furahide.
Thank you very much for being very concise, and you promised that you were not going to speak for long, and you didn't. And I think you've also raised very critical issues on access to justice. And what we are seeing in this session is the same issues are coming up. Enforcement, ensuring that people know their rights, yes, but also access justice, because rights that are not enjoyed are really not meaningful. The very last presentation is by Kome. And Kome was supposed to have presented yesterday, and he didn't get the opportunity. and he's going to be presenting on enhancing access to justice through corporate social responsibility by private companies. So, Kome, you have 7 minutes.
Thank you very much. I hope I'm audible enough. Yes, my name is Robert Kome, as I have been introduced. I will not take much time. My paper seeks to assess how the private sector can be brought on board. As we are all aware, in matters of access to justice, mainly we have involvement of the civil society. We also have the involvement of state actors led by the National Legal Aid Service. But if you look at the involvement of actors in the justice sector, there is very little involvement of the private sector or even the business enterprises. Maybe in this room, you already know that we do not have any CEO of a large company that is making huge profits to come and discuss on matters of access to justice. Why is it that we can't have such people in such discussions? It's because there is no way we have involved them in the legal framework. And I'm looking at strategies that can be employed to bring on board these actors so that we can have access to justice being a responsibility of not only the state and civil society organizations, but also business enterprises that operate in the societies that we have. And in doing this, I'm looking at corporate social responsibility as one of the avenues that can be explored. Currently, there is no direct legislation on CSR, but there has been a development towards legislating on CSR. In 2014, India introduced a legislation through the Companies Act to have CSR as a hard law. It has been largely a soft law, but my argument is that we need to have a framework within which CSR can be legislated upon as an avenue that can be used to bring on board the business enterprises to come and contribute in promotion of access to justice or in enhancing access to justice. I'm also looking at incentives as another strategy that can be used. So in this, I'm looking at tax laws and procurement law as avenues that can be explored to bring on board the business sector in promoting access to justice or in being duty bearers in promoting access to justice. So in talking about the procurement law, we all know that the government spends a lot of money on public procurement, and public procurement has more than economic objectives. Those of us who have studied procurement law understand that there are social objectives of public procurement law, and these social objectives can be explored to introduce an aspect that can force the business enterprises to be involved in respect for human rights and in a way that can be elaborated to contribute directly or indirectly in enhancing access to justice. I was just wondering, as I was exploring this, if we can use even the National Legal Aid Service as an entity that can champion this by utilizing the fund that it has. What if this fund can be a contributory fund such that these business enterprises can contribute a certain percentage? Maybe we can have a certain threshold that will then determine which entities will contribute to this fund. And that way we'll have involvement of the business sector, other than just having the non-profit making entities being involved in enhancing access to justice. Another incentive that can be used is the use of tax laws, or maybe having tax breaks that can be explored. But this, I do not have time to elaborate on this, but my paper largely seeks to explore ways of bringing the business sector on board as duty bearers. So as I conclude, I was just doing the highlights of the paper, and the paper will then proceed by doing conceptual analysis of CSR underpinnings to try and find out how can we legislate on CSR, and how can we do legislative interventions to introduce incentives that can bring on board the business sector to contribute to promotion of access to justice. I'm guided by the UN guiding principles on business and human rights, which also enjoin the state to protect against abuse by third parties, and these third parties include business enterprises. So these principles also state that governments should set out clearly the expectation that all business enterprises domiciled in their territory should respect human rights. So there is international appreciation of the fact that we need to involve the business enterprises in promotion of access to justice and respect for human rights. And locally, we do not have express legislation that captures that. And that is why I thought then we need to explore this idea and see if those strategies I have mentioned can be useful to achieve that. I will stop there, and thank you very much for listening.
Very much, Kome, for bringing in a business angle to this whole question of access to justice, and exploring the way of enlisting more actors. And I think one of the things that you've talked about, this whole issue of public procurement, you know, we probably don't realize how big a share of business public procurement avails to people, and the need to begin looking at how can those who get to do business also contribute to what enables people to access justice. And I think this is a critical issue when you're looking at the role of business beyond making money. So now we've come to the end of the presentations. This is 1:15. We are going to have 15 to 20 minutes. So if you have something you want to raise, contribution, a question, and I'll borrow from Wairimo, who said, make it short and sweet. So if you can't say it without using too many conjunctives, then it is not sweet. Okay.
My question, not question, but comment, maybe something that we need to relook at from her presentation, was the issue, the fact that she had mentioned that most cases people prefer going to court, and that's why we have backlog. However, when a survey was done, or we looked at the river of justice, we noted that very few people go to court, despite the fact that we have the case backlog, but it only contributes to about 20% of the cases. Most people resolve their cases outside court. So perhaps we need to just clarify on that and maybe do further research on that. Thank you.
So the importance of knowing how many cases go where. Yeah, because you see, we are talking very broadly about these issues. So as we invest in legal aid, I think it's also important to get our baseline correct, so that at the end of the interventions that we have, the issue that Ruth was raising about M&E will help us know what have we managed to do, how many people who are not accessing justice have we now enabled. So there is a second question.
Thank you, Prof. My question goes to Commissioner Moma. In light of interaction in Aero, the project they were doing in Aero, interaction with the widows and the Luo Council of Elders and other professionals. Now, in terms of the concept of wife inheritance and the practice, what would you say informs the gaps? That clearly, from what you are saying, there are gaps between the idea of wife inheritance as a cultural practice and, of course, the practice itself.
You take the question down, Commissioner. Can we have any other question? So we have the men at the door. Can you come in so that people see you? You give him because it's taller.
All protocol observed. My name is Kevin Amasa, Faculty of Law, on the verge of becoming an alumni. So my question is in respect to the denunciation of harmful cultural practices. So earlier, a presenter talked about widow inheritance, and my question is in respect to the fact that there are various situations where there are women who are deeply engraved in such harmful practices, such that they don't see it as a violation. So, for instance, a lady can say, "I cannot marry a man who cannot beat me," or if a man cannot beat me, then he's viewed as weak. Therefore, I cannot marry him. So, what do you view it? How do you go around it? Because does it become a problem, or how do you solve such a situation to those women who embrace it?
That sounds like your question. We have a young man here who let that one speak, Kennedy, then you will ask. Yeah.
Okay, so my question is also actually similar. It's drawn from the same well as my colleague who has just spoken. And actually, in the formal versus informal debate, what actually happens, as I have viewed and as was viewed throughout this whole process, when informal is alluded to, we only view the negative aspects, and formal is viewed with regards to how better it is and the formal aspect. But we have the issue of justice must not only be seen to have been done, but must be felt to have been done. And this involves actually both the parties. So in an instance where justice is different to different people have a different sense of justice. And the issue of repugnant things that are viewed in the formal system as repugnant, such as murder cases being solved, where the sanctity of life or the rights of are being considered. When we consider the rights of the living, the surviving relatives who are just as important as the deceased, where the parties feel like justice has been done. What is the place of the government in coming in and saying, no, you know what? You might feel like justice has been done, but we don't feel that way. This person must be locked in jail, must be locked up in prison. Is this really justice, really?
You know, these questions are not all for Commissioner. I am looking for Alvin Kosgei. No, I'm looking for Alvin Kosgei, Jemima Kelly. Because they need to be shared. We need to share the questions so that we get cross. Yeah, Jemima can take that. But where is Alvin? Then Kennedy has a question.
You've forgotten us.
No.
Okay, thanks so much. They said that when a conference is ending, don't ask question, give suggestion. So I'll give suggestion. I was just imagining where I was seated, and particularly if you have been in community implementing programs that really touches the heart of the community. I'm imagining if this session, there were no papers, but people are presenting their issues in some village in Gotmatar, wherever that means, it's a place. Oh, yeah, it's a place where the team seated here, we are not presenting papers, but we are listening and documenting cases of the community, and then using this to actually come up with the real program that really touches the community. I'm telling you, the issues in communities on access to justice, sometimes they're imaginable. And I think for me, the thing is, how do we take this sitting where Professor Lumumba is seated in my village in Mundeku Primary School in Huisero constituency, listening to what really informs and how people are going through issues. It's not a question, for sure.
Tafakarini hayo. So we'll have now Dr. Charles Kamala ask the question.
Yes, before my question, I wanted to thank Robert Mutembei, because yesterday when we were imagining that we have to, let's say, couch our arguments in ways that are donor-friendly so that we can get some funding for these noble ideas we have, I was asking myself, but what about our own initiatives about fundraising, and particularly, I didn't know how to phrase it as in CSR. I was wondering, can you legislate philanthropy? Because I see legislation here, philanthropy here, and different motivations behind them. And I was even going as far as wondering about the whole Harambe, formalizing it so that it can be assist the legal aid, but he has put it in better words than I could have thought of. So my question then goes to, his name was Samuel Mwai? Yes. Okay, you said certain things that I was learning. Maybe I'll have to speak to you afterwards. But I have a client in Rwanda who cannot get justice from those courts. So when you are saying things like Rwandan court has very good mediation and so on, maybe now I have some ideas I want to try. That man is coming to Kenya to look for legal aid because he cannot, and he's an advocate, he cannot practice law in Rwanda because President Kagame will not let him. He tried to form a political party. He spent 4 years in prison. So now he can't work for the past 5 years. I don't know how to do it. He doesn't know where to go. But now I hear that you are saying, in fact, he doesn't trust the courts. I'm glad to hear that you say that it's a requirement that mediation be pursued before going to court. And we haven't thought of that, and we haven't tried it. So I just wanted to know what your experiences are, more detailed about the Rwandan justice system and why you have confidence in it when all the indicators I'm getting is that that court is controlled and the justice is massaged. Yes, thank you. And for the legal aid providers, can it be cross-border, or must it be legal aid for something happening in Kenya? Because there are also our brothers who across the region who are in need of some sort of aid and they are not getting it within their borders.
Thank you very much. We have one more. Let's have this question and then we have that one. And we have a couple online.
Thank you. I I've listened, I've learned a lot, we've all learned a lot. And I must admit that I have been crisscrossing between the formal justice system and the traditional justice system for the past 2 days, even in relation to my experience in the Northern Frontier, especially with regards to contextualizing the justice system. And I hear how we are all just, we are all in between two worlds, and which is good. And I think that we need to take the good out of each system and leave out the bad. Yeah, we are very cognizant of some of the things that are not in our culture that are very prohibitive and or not good. I mean, for example, in the Northern Frontier, there are times I go out to talk to the old men to insist to them that the women should come out, and they look at me like, this small girl, what could you possibly be coming to tell me as an old man? Just like Commissioner said about her not that with regards to FGM, it's not really the men who actually advocate for it's the women who actually insist that the girls need to go to get the cut. And that shocked me, that blew my mind, because then we thought the men were the actual culprits, but it was actually the women who ensure that the girls are ready for marriage by taking them through. Anyway, that just blew my mind. Therefore, contextualizing what is good within our culture and ensuring that we incorporate it into the alternative justice system. My question is, I wanted to ask Jemima, former ODPP, do the prosecutors actually, are they trained on AJS? Is it something that is being done? Because I'm trying to recall how many times I've seen prosecutors actually advocating for alternative justice systems in my interaction with them as a legal practitioner, as an advocate, in any sector. And I rarely see that. It's more of what are your returns for the month? How many files? How many? Yeah, just if you could just let us know about that. Thank you.
I've just realized that I have been causing damage to private property by spraying sanitizer. So all you who have said, my students, if I have to pay, you will all be in here. So there are people online who want to interject, and I'll give an opportunity. Ruth had names. Florence Shako, you want to engage? You have the floor. 1 minute.
Absolutely.
Yeah, you have 1 minute.
Okay, I wanted to comment on Come's paper, which was fantastic. I liked the interventions about the business community. And my question to him is, where do we draw the gap between corporate social responsibility and business and human rights? Because on one hand, CSR is very voluntary, BHR tends to be more mandatory. So what is that intervention in terms of what you want companies to do? Should it be a voluntary participation, or are we trying to put in guidelines so that they're actually mandatory obligations on their part? And thank you for that fantastic presentation, Kwame.
Thank you very much, Florence. I think there was another intervention from South Africa. Mataywa Busieka, is that it? So if you can...
Yes, Chair. Thank you very much, Chair, for the opportunity, and thank you for presenters for those very informative and very thought-provoking presentations. Chair, mine is the same as Florence Shako, that intervention of Kome. Remember, it addresses the question I raised earlier, which was not responded to, that how do you bring private sector into participating in promoting legal aid as a very important imperative of promotion of human rights. And I haven't read his paper. Of course, he didn't have time to delve into it because, as Shako says, human rights is too broad. My concern was, where does legal aid sit within that human rights, within that basket or budget? And I see, if I can share the South African experience, and I think he's right when he talks about procurement, effectively using procurement law, because I do know that you can't legislate CSR, because these are voluntary. But you can effectively use procurement laws to influence behavior or expenditure behavior. In South Africa, for instance, if there is a big project of say 2 billion that's being established somewhere in some rural area, it will play in your favor if you are to say, for instance, I'll set out I'll improve a certain court infrastructure, or I'll improve a certain road infrastructure in that area as part of corporate social responsibility. And it's very rare to find companies bidding for procurement without introducing that element of corporate social responsibility. So my question to the forum is that within the competing priorities, how does legal aid place itself or position itself as one of those considerations that can come into this procurement process as well? Because we have infrastructure, we have issues of environment that come in, and we also have issues of health issues. These are very, strong. These are very pressing matters. But the problem with legal aid is that, people don't necessarily see law or justice as a serious priority, because for the better part, you find that people would rather do other things than until they get into trouble, until there's problem. But these are very pressing issues. So I'm not sure whether Comet's paper will be addresses those issues in more comprehensive manner, especially if you look at a comparative analysis of what is happening in other countries, but for legal aid. Thank you, Chair.
Thank you very much. I think, do we have any other online intervention? I don't think we do. So what we are going to do, I'm going to give the microphone to Dr. Wambua Kituku, as he now is, formerly Mr. Wambua, when he came to the conference, and let him contribute. And I'm told there is one more person who wants to contribute. It is?
Questions? Okay.
Is legal aid available for divorce to pay for legal costs? I will pick who will answer that one.
Okay. Thanks, Professor Mbote. I should have said Professor Kamari Mbote was my supervisor, so she also needs to be applauded for that. Yeah, my question goes to Alvin. Should the state play a role in the self-regulation of these traditional justice mechanisms? And also, should we consider having this, the representatives of these mechanisms represented, for instance, in the Judicial Service Commission, the National Council on Administration of Justice? Because if they are not there, then how do we ensure that policy is geared towards better recognition of these mechanisms? I imagine if we want to have judges who are decolonized in their minds when it comes to application of customary law, then you'd need somebody to ask those questions in the interview panels at the JSC. So if these folks are not represented there, or their interests are not represented there, then we may never achieve that aspiration. Then for Mutembe, just a comment. I guess, yeah, CSR is voluntary, but there are companies or self-regulatory forums for companies that have come up with CSR guidelines. And in the extractives, to obtain the social license to operate, guidelines would require those companies to set up schools, and such infrastructure, just to get the buy-in of the communities where they want to set up the extractive industry. So can we also lobby those self-regulatory forums to include in their guidelines contributions towards the legal aid scheme, so that when communities in those areas where they are setting up those industries can be empowered to raise complaints or bring their grievances against the extractives activities in those places? Thank you.
Okay, thank you. I think we have a good group of questions. We have how many minutes to answer them? We don't have many minutes to answer them. There are 4 people. They are questions for the commissioner. Kelly, we picked you. You're going to answer a question. Jemima, former ODPP, you also have a question to answer. Kome, you came and brought a broad theoretical underpinning. And if you listen to the question, Didi raised, and the question, somebody else raised the question about traditional justice systems. And we want to hear your comment on that. Moi, there was a specific question for you from Charles about access to justice in Rwanda. And Kome, your paper has just expanded. You need to comment on that. So let us manage time well so that we get done. I'll begin with Commissioner.
Thanks, Prof. The question to me was, what informs the gaps on widow inheritance? What we found out was that the manner in which the culture on widow inheritance was used in the context of HIV brought a conflict and ended up being used to abuse the rights of the widows. The reason we called in the leaders from the community to specifically discuss and pronounce themselves on what this culture was all about was to set the record straight on what that culture was. And in that forum, they actually confirmed that this was a social security system. It still is a social security system. But as you know, culture is dynamic, and as it has moved, people sometimes will use culture for their own personal, selfish interests. So what was happening, or what is happening, is the younger people, as land has become smaller, they find that this widow is young, vulnerable, they don't know, so we can abuse culture in order to get more land. And that was the situation. And as I have said, in every one of the cases where we've gone to the elders, they were all reinstated. There was a sense of shame by the families, the in-law families of the widows, in terms of resolving this issue. The other thing is that we tend to go for newsworthy issues. So when we are discussing widow inheritance among the Luo, what the other communities see is the abuse, is the negative bit. So you are likely to only hear the negative part of that culture and not the positive. So it helps if you are going into a community to ensure that you understand, you get full knowledge around what you're trying to deal with, and then isolate what's positive and what is negative in order to deal with that. Prof, allow me to abuse the space for just 1 minute. To come, 2 things to think about. How do you integrate the issues of ethics? If you get a private person funding legal aid, and maybe it is legal aid that is going to set precedent or shape policy that affects them as employers, what are the chances that they might be influencing in order that decisions are made in their favor? That's one way. 2, just to build on Dr. Wambua's case, there is something called social risk management. Maybe that's the way to go. How do we ensure that particularly the big investors in infrastructure provide pay for an opportunity to ensure that the disruptions they are likely to cause in communities are provided for in terms of allowing full participation and resolving of conflicts that are likely to be caused by infrastructure projects. So that's something, and I think SRM, the World Bank has a project on SRM, and they're trying to lobby for policy development around social risk management in development projects. Thanks.
Okay, thank you. I'll take two questions. One, because I have information about, and the first one is the specific one that was directed to me. Okay, so this PLEAD program, I happen to be one of the pioneers in the ODPP, because ODPP is one of the organizations or agents that are being supported to promote alternatives to prosecution and reduce incarceration. In this regard, the ODPP developed diversion policy and guidelines, and developed plea bargaining policy guidelines and explanatory notes. So in the diversion policy, in both documents, I happen to participate in development and sensitization. One of the requirements is that all prosecutors must be trained on diversion and on plea bargaining. And these trainings, we did them through counties, specific regions, for instance, Mombasa, Northeastern, and other areas that are being covered under the PLEAD project. But in essence, the two documents, or one of the issues that is required, is all prosecutors or the prosecution councils must be able to fill the number of cases that have been referred for alternatives to prosecution, either diversion or plea bargaining. And we've developed an M&E framework to be able to monitor the number of cases and the outcomes. And this also is covered under the Prosecution Training Institute. All prosecutors who will undergo induction under the PTI will be trained on alternatives to prosecution. Lastly, on the issue of NCAJ, I remember last year when we had the conference on criminal justice system reforms, one of the resolutions was to have NALAS, I think it's now called NALAS, to be represented in the NCAJ. So perhaps not in the Judicial Service Commission, but I know that there were to-do letters so that they can be represented in the NCAJ, which is the umbrella body that makes decision in regard to criminal, in regard to legal issues in court. Thank you.
Thank you very much.
Thank you, Prof. Prof introduced us to some of these ideas we are talking about here, but now I am very apprehensive of identifying myself as a student, because she said we might be involved in paying for private property that has been destroyed. But anyway, away from that, to the question Doc has asked, whether or not the government should be involved in the issues of traditional dispute resolution mechanisms, my quick answer is yes. And I would say that it's the realization or the establishment and recognition of these traditional dispute resolution mechanisms, and how that can be, if you look at the South African case that I quoted, the involvement of the government is in aspects such as financing the sittings by sitting allowances and providing for venues where these tribunals, quote unquote, sit. We know that under the customary justice systems, there are ways in which these leaders and elders are compensated for their time, but it would be important to ensure that if we are to have a proper and institutionalized system that delivers justice to the people and brings government closer to the people, as required by Article 1 of the Constitution, the government is involved to that extent, and to the extent also of formulating policies which can be more or less like model laws that can be adopted by the county governments in coming up with the structures for recognition, procedures, and things like those. And my paper also talks about, if possible, establishing a national traditional dispute mechanisms authority, which has, among other people as the members, a representative of the judiciary. So I think that answers your question, Doc. I think before giving away the microphone, it would be important to briefly address the question of the repugnancy clause. Like I said, under this proposed paradigm of decolonization, it's important to start from the right place. Indeed, it is true that there are certain aspects of our customs that might not fit very well into the culture that we have today. But in the same way, there are negatives in our African customs and cultures. There are also negatives that can be identified in the Western notion of justice systems, which is revealed through our formal laws. So it's important to start from the right place. And if you keenly look at how policy has been shifting, we are slowly recognizing that there are certain good things about certain customary institutions, and institutions in this respect speaks also to the legal policy aspects that we find in the Community Land Act, in the Traditional Knowledge and the Cultural Protection Act, and things like those. And if you read scholars like Yokai Benkler, who thankfully also Prof introduced, and the areas of software development in I think a paper called The Future of the Farm, people are now seeing the benefits of that communal way of life. So I think I'll stop there. Thank you.
Are you registered for PhD? The next person is Jemima.
Thank you, Prof. Let me just answer the student who asked about state intervention where the TC justice was not done under a traditional dispute resolution system. There are three critical state actors in the criminal system: the arresting officer, the prosecutor, and the court. Those are the three who can intervene if they think justice was not done. And this was done in a case reported from Mandela Law Courts, whereby Honorable Wasike presiding, in a child defilement case, a child of 15 years, a girl, was defiled. The case was presented in court in January this year, and the girl gave birth around May 2020. And in July, there was a turn of events. The prosecutor informed the court that the accused has since married the victim, and they have been blessed with a 2-month-old baby, and that the marriage was solemnized by a sheikh from an area called Bula, and there was a marriage certificate. So what the prosecutor tells the court that the matter, it was not in the interest of justice to proceed with the case. The magistrate rejected the prosecution request and said a child under 18 years is incapable of being lawfully married, and requested the prosecution to provide witnesses so that the case can be heard and determined. So you can see that is an intervention at that stage by the court. As I said, these three actors, they are critical in the criminal justice system, and it's upon them to ensure that, because even in cases which are sorted out under traditional justice systems, they have been reported. So the arresting officer is one of the people who holds the key to the justice system. If they do not, at that stage, arrest the person and present them to the prosecution, then the gates are locked at that stage. So that is my intervention.
Thank you very much, Jemima. Moi, very briefly.
Okay, thank you. My question was from Dr. Kamala. And I think the question was on two sides. One was to do with the issue of mediation before going to court. Then the other issue was, I think it was something to do with interference. So in regards to mediation before going to court, actually Article 21 of the law governing mediation and arbitration in commercial matters in Rwanda provides that it is mandatory to produce a certificate of mediation, that is, if mediation did not succeed before a matter is received in court. Then similar provisions are also in the law relating to civil, commercial, labor, and administrative procedure. And there is also the law on a Bunsi committee. Those laws provide that before you file your matter in court, you must have or demonstrate to court that you tried all alternative dispute resolution mechanism and they did not succeed. So the second part of the question, he talked about somebody who has tried to make some entrant in regard to a practice or something related. And the beauty of it, I was following up with the question until I heard about something to do with number one. When I talk of number one, I'm talking about the president. So when it comes to politically charged cases or highly political cases, I also have an issue with that. But in these other cases, I think the process is good. Lastly, he said that he'd like to have a chat. Yeah, I'm available. We'll be able to talk more on that. Thank you.
Thank you very much, Moi. We'll now have the final intervention by Kome, aka Mutembei.
I will be very brief. I note that there are several questions which have been directed to me. There was one question from Florence Shako. She was wondering how we can make CSR mandatory. And my proposal is to have a provision through the Companies Act. Currently, we have Section 143 of the Companies Act providing that there are certain factors that directors of companies ought to take into account. And in that list, under Section 143, there is inclusion of aspects of CSR, matters like environmental, taking care of the environment, rather. I think it also touches on what Commissioner Muma mentioned. And another approach that would bring it to be mandatory in a way is the use of public procurement law. Currently, we have the use of public procurement law as a tool for social policy, other than just a tool for economic policy. So we can have certain provisions included in the Public Procurement and Asset Disposal Act to take into account certain of those factors. There is something that Dr. Wambua mentioned, and I think as Professor Mbote mentioned that my paper is expanding, so I'm also taking in suggestions. He made a suggestion on the use of self-regulation. He also made a good suggestion on the use of licensing as a tool to enforce this. And I think that was a good idea, which I will also include. Matayo from South Africa mentioned about the use of comparative analysis, and that was very good input, which I'll also consider. I note that there is one writer, Phoebe Bolton, who has written about the use of public procurement as a tool for social policy in South Africa, and I think it borrows, it is in line with what Dr. Matayo was mentioning. Maybe lastly, to Commissioner Muma, she was wondering about ethics, and yes, that is a very genuine concern, and I think how this would be structured in my proposal is to use NLAS so that the fund that is created under Section 29 of the Legal Aid Act can be contributory, so that the contribution that these business enterprises are making, they are making through the national organ, and then this fund is more like an insurance fund that then is used to contribute to legal aid. So I think I hope I have responded to all the questions, and I'll stop at that. Thank you.
Thank you very much, Nkome, and everybody. I think you've been a very good audience. All good things come to an end, so my short reign is coming to an end. And I'd like to, there's one question that was not answered, and I'll ask, I think there are two people who will speak in the closing, is Professor Lumumba and Dan Juma. Dr. Dan Juma, you can answer whether there is legal aid for divorce. Because you see, somebody asked, we don't want somebody to have a legal aid need that is not met. So thank you all very much. Let's clap for everybody who participated. Thank you. I'd now like to hand over to Professor Lumumba.
So thank you very much, Professor Mbote. I think mine is to try to tease out the issues that have arisen during this engagement. And let us start by looking at the theme of the conference, assessing gaps, opportunities and challenges in access to justice through legal aid delivery. I think in order to determine whether we have been faithful to that subject, it is important to understand what the issues were that emerged. And a number of presentations have been made. First, I think the history of legal aid was identified as critical to our understanding of what legal aid is. And I think that is very critical because we have seen legal aid being understood as something that was foreign. If you look at our history, you'll discover that the United Kingdom, or England to be specific, abolished proceedings which we still retain to a certain extent, proceedings in forma pauperis in 1949. And the whole idea was that it became the duty of the state, the exchequer, to finance legal aid. In the United States of America, your typical pro se litigant was also entitled to some kind of legal aid. In other words, we are coming from a history where we inherited things that are not being done in other parts of the world. Number two, we now appreciate that in terms of offering legal aid, we have been uncoordinated. And uncoordinated in the sense that we have had non-governmental actors in the space for legal aid. That is how you explain FIDA. That is how you explain Kituo cha Sheria. That is how you explain Kellen and all these bodies which are in a space that they ought not to be in, or which should be really occupied by government through the exchequer. But that is important to appreciate, and that was spoken to in some detail. The other thing that was recognized is the misguided belief that legal aid only refers to litigation. And many of us think about legal aid in court, in the court system. So we talk about somebody who is charged with the offense of murder being assigned a lawyer, but we know that that is a very narrow spectrum, as it were. And I think it is Professor Mbote who reminded us that indeed, if you look at the disputes that are resolved through the court system, they are in the minority, if I'm to say so, and that we've got to cast our eyes a little bit more broadly in that regard. Which brings me to the fourth question. How have we handled in an institutional manner the manner in which we offer legal aid? And this brought to the fore the question of training. And training, when I talk about training, I'm talking about the universities. How do we teach our young men and women at the universities? And do we mainstream legal aid as an integral component in the delivery of legal aid to ensure that justice is accessed. We had the presentation from the Council of Legal Education, and the Council of Legal Education did say that indeed one of the things that ought to happen going forward is that universities should be required to have, as a part of training, a component that deals with legal aid. And in the same vein, we talked about the clinical approach to training. Going forward, we said that one of the things that ought to be done is to begin to consider student practice, as has been seen in the United States of America. Somebody talked about Georgetown University, I think is Dan Juma, or I talked about the Case Western Reserve University, and we said that in the context, for example, of small claim courts, you can do that and train people in a manner that makes legal aid something that is an integral component of training of our young people. The sixth thing that was discussed is the deployment of legal aid in the communities. And I think we spent some energy discussing the whole question of customary law. How do we, and I think we have had quite some very useful presentation. My good friend Catherine Muma has given us very practical examples. And we saw how the customs and other traditions are deployed. I would like you to read. It is an article that was written by Martin Luther King Jr. as a student in Boston, Massachusetts in 1953. The title of the article is An Exposition of the First Triad of Categories of Hegelian Logic, Being, Non-Being, and Becoming. And in that article, what Martin Luther says is that when there are competing ideas, and I'm talking here about the whole idea of whether we have traditional dispute mechanisms and the so-called modern, he says when there is a new idea, that is the thesis, the opposing idea is the antithesis. And what happens is that it creates tension. And when it creates tension, then there is resolution. And that he calls the synthesis. And he says that synthesis gives birth to a new thesis, so that the bad things are abolished and the good things are preserved. And I think that Martin and Hegel get it spot on. That when we talk, and the young Natasha it is, Onyango, Mr. Nyango, Chantel, the young Chantel, you are spot on. That through the thesis and antithesis, you have the synthesis, so that the bad elements are purged and only the good ones are retained. And that is how Catherine was explaining about widow inheritance, and we have other things, sorority unions, woman-to-woman marriages. Sometimes when these things are rendered in English, we lose the true flavor of their meaning. But when you speak in mother tongue, they have a totally different way of dealing with it. And I think that also brought us to the question of gender. And I think it is Lichuma and Catherine once again that said that even when you look at the Legal Aid Act, there is this tendency, that is the seventh thing that I think emerged, there is this tendency to argue that we should have gender-neutral language. And the argument was that gender-neutral language has the tendency of disadvantaging the female of the species, and that therefore there is wisdom in drafting that particularizes those who have been disadvantaged over the years. And I think that that is something that is very critical going forward when we look at, and I think Dan Juma, you'll answer the question about divorce either way when you come to that particular issue. So the particularities and specificities of communities are very important, so that the whole idea is that we don't have a binary approach. And I said this myself during our presentation, what happens in Pokot is not necessarily what happens in Meru. The other thing that emerged was, the eighth thing is the whole idea of decolonization. If you are to have a word that has acquired currency during this particular engagement is decolonization. And many of us who are in this space know the works of Ngugi in terms of language, the works of Achille Mbembe, and other commentators that have talked about decolonization. And I think that this is critical when we are talking about legal aid. And the new Daktari here, who, when you are talking about things in communities, it is important, therefore, that when we are engaging communities, we are very clear about what legal aid is all about. And the eighth thing was that legal aid should not be seen as the preserve of your formal court systems. We recognized that when, for example, and I gave this example, when the Egerton University is involved in training people in different parts of Nakuru, you are thinking about land transactions. How do you deal with them? You are thinking about some commercial transactions. How do you empower the people to engage with them? And we are also thinking about non-formal avenues for dispute resolution. Who do you deploy in that regard? And I think that that is germane to this particular discourse. We then talked about children. Professor Wabuile gave us some ideas about how to have a discourse or rather engagements when you are dealing with children and how you deploy legal aid in that arena. And I think that that is very critical. We have seen that these are people who are disadvantaged. We had some empirical information from Justice Madheka through our own experience in how you deal with children and the law. And I think that that also is a very important thing. Dr. Hamala also, as the 10th thing, told us about international tribunals. How do you deal with these things? And today we have had the whole issue of corporate social responsibility, the role of the private sector. What should the private sector do? How do we deal with it? And somebody posed a question that was not answered. How do you incentivize the private sector? And somebody, of course, do throw a word of caution that how do you deal with this when they may be involved in a manner that will benefit them. But there are different ways of doing it. You can have tax rebates for those who engage in CSR in a manner that supports the system. I think those are issues that emerge. Then we also reminded ourselves that you need to monitor and evaluate what we are doing. Otherwise, we will be running rings and appearing to be doing things that really don't benefit us. In other words, what we do must be measurable. And how is it measurable in the communities? In my understanding, it should be that if you are in a community in year one, and you intervened through training and through legal aid, and you visit the same community in year 3, they are able to say that they are the richer because you intervened. And I think if we deploy tools that enable us to do that, then it would be a useful thing. The 10th thing that was mentioned by Professor Wabuile is what he described as the donor capture. And I think this is something that Dan will speak to, and he actually did speak to it during our last engagement yesterday, that there is a sense in which those who finance, and we are not averse to being financed, but they too have a very, what I'll describe as a very jaundiced view of justice. And I say jaundiced because their understanding of justice is justice which is very Eurocentric, which is what legitimizes our constant punching of the Repugnancy Clause. Mm-hmm. When the Repugnancy Clause was introduced in 1897, that is repugnant to justice and morality and inconsistent with any written law. And that is why, therefore, when Professor Mbote was talking about Eugene Cochrane's restatement of customary law, Eugene Cochrane is actually trying to ensure that customary law in its restated form is now written. But that fossilizes and brought us to what was described then, that when you formalize the informal, you then lose its flavor. And I think that should also be seen in the context in which we teach law. But the point I was trying to make is donor capture. How do you deal with that? Because they have funded you. They want you to conduct yourself in a particular way. How do you deal with that? And the 12th thing that was talked about is, who are the players? As I draw to the conclusion, who is involved? Is it the national government? Is it the county government? And we saw that the way that the architecture of our government post-devolution is that you have these parallel strains that sometimes are conflictual. How do we ensure that they are not conflictual? And I do not know who posed, but my memory now serves me well. It is Professor Mbote who posed it rhetorically. Is the chief a colonial relic and therefore a post-colonial institution? Is the clergy a post-colonial relic or a post-colonial institution? So that when you go to the Catholic Church and a dispute is being resolved by the father, how do you deal with that? Or you go to the chief at a baraza and they are using the Chiefs Act to resolve, is that post-colonial or a colonial relic? So there are many issues that have arisen, and what I've tried to do is simply to tease out the things that I consider to be germane to this discourse and germane to our own declared theme, and that theme being that we are assessing the gaps. We are asking ourselves how we access justice as contemplated under Article 48, and how we think that legal aid plays an integral part in that regard. And that brings me to the closing question. And I just want to give you two experiences about justice and who, because ultimately we are talking about justice. Gacaca, which we talked about in Rwanda. You know, justice sometimes can be very specific, but whose justice? That is the question, and I'll have no answer for it. But Gacaca, if you look at the way and the manner in which it was deployed, did succeed. At least the juries may still be out in that regard, but part of the stabilization of the post-genocide Rwanda environment is the Gacaca. Had you left it to Arusha only or to ICC, I don't think that Rwanda would be where it is. The second one is Mozambique post-independence. When those who had collaborated with the Portuguese colonialists, there were two issues that were being put forth. There were those who said these individuals committed treason. And President Samora Moises Machel said, yes, from a Portuguese perspective, they did. We can try them, we can hang them, but they are in the thousands. If we do so, will we resolve the problem? And this is what they decided to do. They went into some Shoshangane tradition and said, what we'll do is to shame them. Their photographs would be hung up in public for a period, and once we have done that and we are satisfied, then they'll be called to a rehabilitation forum at which they will be rehabilitated, and it will solve the problem. So in a nutshell, I want to conclude from where I sit that the engagement that we have had here has been very rich, and I'm certain that the rapporteurs, who I believe were recording our contributions verbatim, will have captured many of the things that we have talked about, and I think that this has been a very enriching engagement, and I thank you very much. God bless you.
So this is really not a presentation, but a response to the request by Professor Mbote that I speak. Of course, I was not prepared to do it, but I'm going to do the same because I've been part of this conversation over the last 3 days. Let me very quickly respond to the question about divorce and with some statistics. On the first day, recall I mentioned the Kenya Integrated Household Baseline Survey, which was done by the Kenya National Bureau of Statistics. And they basically were looking at the issue of access to justice under Chapter 12. And they noted over 15 organizations or entities that Kenyans go to. This is a survey done by a national entity with a very broad sample, and therefore I think statistically very, very valid. They noted, land, of course, cases being the biggest, and so what would that come down to? The issue of squatters, allocation, use, boundaries, ownership, etc., etc. Disinheritance would be one of those, of course. Commercial, that would relate to unpaid debts, the ones that Ms. Mwangi spoke to. Could be issues of course, also goods and services, perhaps not delivered, and so forth, business disputes and so forth. Family matters, divorce, paternity, child custody, maintenance, and so forth. Succession and inheritance, of course, was again one of the areas. Criminal cases, theft, assault, and name it. Natural resources, tenants versus landlords, disputes over personal property, given that the others were real property, domestic violence, labor, traffic cases, religious and witchcraft offenses, political disagreement, and so forth. So clearly one can be able to see that divorce falls under one of those areas where legal aid can be sought. But also looking at legal aid from a more capacious perspective, as I mentioned, this survey looked at the 15 places to which people go to. And sorry, these are little tiny. There was those try to resolve it with the other party, extended family members, religious institutions, chiefs, assistant chiefs, other national government officials, county government officials, traditional leaders, MP, MCA, NGO, CBO, lawyers, police, courts. And the courts, I think in relation to these family matters, mostly were going to only about 22, actually not 22%, but 13%. There is also the friends, others going to friends. Gangs was mentioned here as one of the people, of the entities that people seek access to justice, which points to the question, the conceptual, theoretical question that we've been asking, what is justice? And of course, others. So I just wanted to mention those, and also just to reiterate, I think, the complexity of the subject that we've been dealing with over the past 3 days. And of course the diversity. I think really what is emerging is that what really has been imagined can be reimagined. I think Professor has really talked about the issues that have arisen over the last 3 days, and so I cannot do any more justice to reiterate them. But I think for me really is the takeaway here is how we as part of the epistemic but also the practitioner community can be part of flipping the orthodoxy, being disruptive. I remember that was a word that was said on the first day. And I think how do we do that? I think Professor has already highlighted how we can be able to have the thesis and the interthesis come together, how we could have these different regime encounters, the different disciplines, the lawyers, the sociologists coming together, and of course the different entities coming to think about really what it means to access justice, and really what it means to open up the different pathways of accessing justice. Noting very, very, clearly that, in our own context, the contexts are certainly different, but there are both the formal and the informal. There are times when the informal get into the formal as well, but also being just aware that we do not, formalize the informal. Now, I think for me, just to end, just with one or two points, as sitting from the side of UNDP, which partnered with the Faculty of Law project to convene this, conference, really seeing how, despite the theoretical, conceptual debates we've had, this has been a very practical-oriented discussion. We've had, judges speak here, we've had practitioners, we've had professors, we've had the people themselves who've been doing access to justice in the trenches. And, just seeing how we can go from here, how we can be able to translate based on the report that we've had, translate those really into practical policy solutions. One very interesting thing that as Kwame was presenting, on the CSR, and I was reminded of the origins of courts in this country. Initially, actually, the formal courts, the colonial courts were established by the British Imperial Company, Aberco. And if you even look at how and where the initial courts were, they were along the railway lines. And so that tells us something about, what, the corporate sector can as well do. Of course, that was in a different context. But I think that raises an important, avenue in terms of providing practical solutions, how, despite the fact that we know it is the state that has the primary responsibility, if we take, the idea of rights having the correlative duty, it is the state, but that also, requires some kind of a concerted efforts among the different partners. And this is where, civil society organizations come in. But I think the caveat that has been raised over the last, since yesterday, is that issue of the donor kind of predispositions. I would really say, obviously there are also partly, some of these are ideological, as you know. The Western liberal world has its own notions about rights, about access to justice, and so forth. And therefore, when they come, into our countries, of course, those are not left behind. But I do believe that there is space for us, and I think this is at least from speaking from the UNDP perspective, we do acknowledge, and UNDP not actually being a donor, but being an intergovernmental organization that tries to work with countries and member states and their populations from a kind of a bottom-up approach. And this is why when, for instance, we provide a grant to a civil society organization in northern Kenya, which is actually where we are focusing a lot, they have the latitude to be able to do their work, provided that, of course, this will be helping the people who have those justice needs. But I think that's an area that we need to think about and see how to enlarge this conversation. And for me, I think this forum was just the beginning of a conversation, beginning of an encounter for us to deepen some of those ideas. And I do believe that the report that will come out of here will give us some ground for further work. There was a question to end that Dr. Wambua kept on referring to, data and the cost-benefit analysis that have been done on this different forms and pathways to access to justice. I think these are some of the areas that we still need to focus more and see really how best we can use the little resources that we have to ensure that nobody is left behind in terms of access to justice. Those really were what I wanted to reflect on, really, and just to thank all of you who've been part of this conversation. This has really been a tremendously insightful conference, very disciplined participants who've been here throughout since day one up until day 3, sitting through. listening to each other, engaging, not interrogating, as Professor reminded us, to be able to see really how can we be able to advance this agenda of access to justice. Really, those are the few remarks that I can make on behalf of UNDP. Otherwise, I want to thank you very much and give back the program to Dr. Ruth. Okay, so it seems to me that Dr. Ura really is already, the program has come to an end, and so on behalf of...
Before next year, are we coming here?
Okay, that's a good question. So there is the question about next year. I think let's think about that and see where we will go. But for me, just as I've said, this is just the beginning of a conversation. It might not necessarily be here, it might be somewhere else. But as you can see from the debate that we've had, so much remains to be done. And I think based on the interest that we are seeing here, let's pick up from here and see how we can be able to engage and make sure that really this agenda does not fall through the cracks. Thank you very much.
Okay. I'm not even giving a vote of thanks. It's already been done and everything, so we are just about to head out. Do we do another round of applause for everything that we have done in the 3 days? Have we made a resolution that we are meeting next year? Or
Yes.
Or it's okay. I've already seen that Wambua and everybody else is nodding. So we are meeting next. Now, tomorrow is our Independence Day celebration, right? So we are going to wish each other happy Independence Day, right? What tunaita aje kwa Kiswahili?
Jamhuri.
Jamhuri Day. My sugar level is down, okay? And then, are we meeting before Christmas and New Year? We are not meeting, right? At least not for such a forum, eh? So are we also going to take this opportunity to wish each other a Merry Christmas and a prosperous 2021?
Yes.
There are so many things that we need to curse and crush because of whatever happened in 2020, Cindy? Especially COVID, right? So let's hope that 2021 is going to be prosperous for each one of us. But above everything else, Merry Christmas and Happy New Year. Robert Mutembe is supposed to come and pray for us, so then we just end everything. We have not been praying for food, partly because my bishop usually says, and we are in his area, usually says, you don't pray for food unless you see it. So, okay. And then after that, I think the DJ, for the sake of Jamhuri Day celebrations, once we are done with the national anthem, you will play as Kakai Kilonzo's song as we go out. Ewe Kenya inchi yangu, because partly it's also very post-colonial, eh? And very what? Yeah, it's very decolonizing. Come, Mutembe, and pray for us.
Okay, so I request that we stand as we get ready to end with a prayer. So let us pray. Our Heavenly Father, in the name of Jesus, we are grateful that you've taken us through this conference to this last day. Thank you, Lord, for the grace that you've given each one of us. Thank you, Lord, for the strength, for the gift of life, for the good health, and for the strength that we have enjoyed even as we did this conference. Heavenly Father, we have deliberated on many matters, and we know justice is something that is at your heart, and Lord, we know you are interested. And indeed, even as we discuss matters of justice, Lord, we thank you because you have given us the support that we need. As we travel back to various places, we pray for journey mercies. Until we meet again, we pray that your grace, your love, and your mercies will keep us. We pray this believing and trusting in Jesus' name. Amen.
There is no Egerton anthem.